Judges of the court. Hear ye, hear ye, hear ye. All persons having any business before this Court of Appeals, held in it for the state of New York, may now draw near, give their attendance, and they will be heard.
Thank you. Please be seated. Most of you have probably heard by now we're mourning the loss of our former Chief Judge, Judith Kaye, who passed away early this morning. Judith Kaye was the longest-serving judge on this court. She was the Chief Judge from 1993 to 2008. As most of you know, she was an absolute icon, not only in this court, but in the court system of the state of New York, and nationally known for her problem-solving courts and her judicial philosophy. It's a sad day for us. We have our red shoes, which most of you would not know, but Judith would wear when she was serving as our Chief Judge, and we've left the Chief Judge chair vacant in her honor. I would ask you all to please remain seated, but join us in a moment of private, quiet reflection. Thank you very much. Case number 9, Sissy versus Graham.
Ready for court, please.
Mr. Fisher, am I pronouncing your client's name correctly?
Cisse.
Cisse?
Cisse, Your Honor. May I reserve 2 minutes for rebuttal, Your Honor?
Yes, sir.
May it please the court, my name is Barry Fisher, and I represent the appellant mother, Rokhaya Cisse, in this proceeding. This is a child custody modification proceeding, and as this court has repeatedly stated, one of the key considerations to be given in any child custody modification proceeding is the stability of the child, so as to ensure the best interests of the child on a long-term basis.
Counselor, you recognize that obviously we're not looking at this ab initio, and it's not our role in this court to necessarily be weighing all the factors that the trial court and the appellate division did. Do you agree that our standard of review is to determine whether the record supports the findings of the courts below?
Yes. And it's my understanding that if this court finds that the record does not support the finding of the appellate division, that this court can consider the various factors and the facts of the case.
Why wouldn't we support that position here, counsel, on this record?
Because the fact is that the record is not supported, the affirmance by the appellate division is not supported by the facts of this case. In fact, this case shouldn't even have proceeded to a hearing, and it's a tragedy of sorts.
Well, what's the date of the order that we're reviewing?
The date of the order is August 2014.
Okay. What, August 2014?
Well,
I'm talking about the Nisi Prius court, the family court order.
The family court order is from June 2004.
How do we do that? How do we make a determination that an 11-year-old order is or isn't should be applied now that the child is obviously 11 years older?
Well,
the
question is...
I got to blame the courts on this, by the way. I mean, we weren't exactly speedy in this. I don't know why all those things happened.
There was a mistrial, I'm told. I wasn't trial counsel. I'm just appellate counsel. But there was a mistrial. And as a result, these people have now gone through 3 custody trials. There was a custody trial that resulted in the 2004 decision when Anto was 3 years old. There was the mistrial, and then there was the trial, which we're here today on, which started in April 2011 and culminated in April 2013 with the decision. I actually misspoke.
Okay.
It was a 2013 decision.
And this was a motion to adjust visitation or change visitation brought by the mother, which was followed by the father to change custody. Isn't that what we're really dealing with here?
Correct. The mother brought a modification of visitation petition in November 2007 when the child was 6 years old, seeking to modify the visitation to make it more conducive to the child's school and academic calendar. The child was in preschool when the prior order was issued, and now when she went back to school, the child was 6 years old. I'm assuming the child was in first grade. And
My point is that we still have to look at the best interest of the child, and the family court indicated that its decision, although very gut-wrenching and important, looked at all of those factors. It looked at virtually every aspect of this child's life and decided that custody should be transferred to the father, correct?
it did determine that, and I think one of the reasons it determined that was that it appears, and again, the in-camera minutes are sealed, I have not seen them, nor have my colleagues, that the child expressed a preference to live with the father.
That was one factor.
That was one factor, but it seems that the court gave that a very strong consideration when this court has repeatedly said that is not a particularly weighty factor, given the fact that the child who was 11 years old or 12 years old at the time lacks maturity and intellect and knowledge to determine what is in her best
Saying that
interest.
court gave undue weight to that factor? Is that what you're suggesting?
I am suggesting that, Your Honor. I think that given the age of the child, given her lack of maturity and knowledge and life experience, a child can be manipulated, as this court said.
I mean, I get that, and I realize these in-camera things that, you know, you're kind of shooting in the dark on and trying to anticipate this. But don't the judges know what you're now saying? In other words, if you're a family court judge and you want to take into consideration the interests of the child, but also the child's wishes, don't they know that you know it's a factor? But I'm not going to listen just because this child doesn't want to do something that mom wants to do or dad wants to do, and therefore wants to be with the other parent. Most judges know that's not the reason why I'm going to make this decision. I'm going to make the decision considering that, but maybe rejecting it because it makes no sense, and operating in the best interest of the child.
Well, Your Honor, to a certain extent, speaking in the dark. I have no knowledge of what basis the child set for why she wants to be with the child. For example, some children may feel that they're going to have a better time at dad's house and it's going to be more fun.
But we do
My point is,
know-
don't the judges know that? In other words,
I'm assuming, I've never met referee Negron, I'm assuming the judges know that, yes. But how she applied it to the facts in this particular case.
Well, what we do know is what other facts and factors and considerations were looked at, about the mother's ability to care for the child's emotional needs, about which parent would be more likely to encourage a relationship with the other parent, about the child's social needs, the child felt alone with the mother, and the availability of siblings in the father's household. To me, it looks like the lower courts did an incredibly detailed job of discussing what factors they felt added up to showing that it was in this child's best interest to live with the father, and whether the courts may have given a little bit more weight to one or the other, is that for us to judge?
For example, you talk about which parent will foster a better relationship between the child and the non-custodial parent as one of the factors to be considered. The hearing court missed that point in the sense that the father is not going to be the parent who is going to better foster the relationship between the child and the mother. The father already has indoctrinated the child in the Roman Catholic religion, even though the prior order states that they may introduce the child to their respective religions and teach them about their respective religions, the mother being Muslim in this case, the father being Catholic, but there was nothing about the child being allowed to partake in a particular religion. And without the mother's knowledge, the father had the child baptized and had the child receive her first communion.
How did that affect the child's relationship with her mother?
But that goes to whether he's going to foster a better relationship with the mother.
That's what I'm asking.
When in fact he's
That's
going.
an issue. I agree with you that is an issue, and certainly the lower courts were aware of that issue.
So here he goes behind the mother's back and does that. That's not encouraging a good relationship between the mother and the child. The forensic psychologist, Alberto Yohananoff, also found that the father harbored a lot of built-up anger towards the mother. He also found that the father stated to him that the mother was bipolar, which in fact it wasn't. The psychologist also felt that the father's filing of the
point, though,
custody petition was...
Counsel, the point that Judge Stein has made, though, is that all of this was before the other courts, and the decision still was to transfer custody to the father in the child's best interest. What I would like to know, because I did see that apparently most of the factors were considered equal as to both parents, and it did seem to me that the child's preference was a determining factor. So now 4 years or 2 more years have gone by. I guess the child is now 14 going on 15?
Correct, Your Honor.
Do you have any information about whether she continues to prefer to live with Dad and his family, or has she changed her mind?
I represent the mother. Mr. Strauss represents the child, and you'll hear from him shortly. I have never met the child. I've never spoken to the child. I cannot answer that question.
What about, what effect would it, if you had a de novo hearing, what would you argue? You
If
sent
I-
it back.
If I had a de novo hearing now, well, first of
Well,
all...
the mother's circumstances have changed.
Well,
dramatically.
That is one of the problems, and I did raise that in the brief. There are many facts in this case that the trial court heard that no longer exist. The child is
Slow down. What's changed? Just tell me what's changed.
From what I know,
Yeah, from
the
what you-
child is no longer in daycare. The child goes to school in the morning, takes the train, meets her friends. My client says they hang at Starbucks like normal 14-year-olds do before school, then they go to school. So she's no longer riding with the mother in the morning.
Is she receiving counseling?
She is receiving counseling. And in fact, my client reports to me that Anta has gone, and there are times that Anta has wanted to stop. There are times that Anta's been in the custody of her father, and he has not taken her to sessions.
Forget about that. I just want to know what's changed.
What also has changed is the ride after school. When the hearing was taking place, the father
It was
would
that
pick-
long hour ride, which I can see to be tough on anybody.
That's right. It was over an hour. And the father used to pick Anta up in Manhattan, drive her home to his home in West Babylon. I am told now that the father now has given her a Metro card and a Long Island Railroad ticket, and she takes the train from school to Penn Station, and now she commutes on the railroad by herself.
How do
But
we
the father
possibly
created-
consider any of that? That's why I get kind of miffed at our court system, that this thing is dragged out now for, what, 10 years? And
It's dragged on for an exceedingly long time,
I
Your
would
Honor.
be stunned if there weren't changes. Obviously, she's now in high school, I guess, or heading that way.
That is correct. When the testimony in this case
I'm
started,
almost done.
she
And-
was
and
10
so-
years old.
okay.
She was in 4th grade. You cannot compare that to a soon-to-be 15-year-old in 9th grade. I'm sure most of us, if not everybody in the room, has children, and we all know that there's a huge difference in a girl between the ages of 10 and 15. It's an astronomical
I'm
change.
concerned, however, that if we were to agree with you to some extent and send this back for another hearing, that it would only, by the time this wended its way through the courts, she would, she'd probably be a parent herself.
Yes.
I agree with you. And, one of the things that I've learned in the 30 years that I'm doing this, it's the word closure. Mom and Dad need closure. Mom and Dad have been fighting since this child was born. Dad brought a paternity proceeding first, then we've had the 3 custody trials. These people need closure, but more importantly
Well,
than the people...
who is it, wait a minute, let me finish this for a minute. I mean, I'm looking at our court system, dragging this thing out for 10 years, however and whoever did it. Let's assume for a minute we agree with you, and we make an order that you think is perfect, and she says, the hell it is. I'm not doing it, I'm 15, I'm going to do it. You're going to be back in family court. And I don't know why you're not back in family court now, frankly. I mean, it seems to me to be a waste of time to come up here and argue a legal principle that there isn't rational basis and sufficient evidence to justify what family court did and what the appellate division did. Absent an error of law, I don't know where we go.
I would hope we don't go back to family court because it's not in Anta's best interest. What's in Anta's best interest is that she have closure and that her parents are at
You
peace.
say closure because you've got to stay and you've kept the kid.
No, I'm not saying that.
Well, let me tell you something. If that family court order had been in place and she was now with the father, would you be saying what you're saying now? We need closure and let's just stop this thing and let the child stay with the father? Of course you wouldn't.
I would be saying that I believe the child should be transferred back to the mother, but that should end it.
But
There
you'd
should
be
be
looking for a
closure at
legal
that point.
basis for that. The thing is, you got to have a legal basis why we think family court, which went through all of this, and the appellate division, which affirmed it, are wrong, and we need that legal basis. And the problem is, as Judge Fahey was talking about, is we're operating on a 10-year-old petition, and we don't know what's happened in the last 10 years. I don't know that puts us in an interesting spot. Don't you agree?
Yes, I do, and that's unfortunately one of the problems with custody cases, and I raised in my brief that I think custody cases need to be handled on a more expedited basis,
I think you're absolutely
whereby the hearing should start within 6 months of the forensic being issued, and it should be, tried as close to a day-to-day basis as possible, so that we're issuing timely orders. In this case,
What astounds me is that these parents have paid whatever they've paid for this entire litigation, and they haven't been able to come up with some arrangement that suits their child and avoids having 5 judges, plus whoever else has already decided this case, decide their child's fate. That's amazing to me.
I wish that was the case, but in this case, this is not a divorce case. This is a child born out of wedlock. So when, in most cases, more of these cases are out of divorces,
understand, but
and the
there's
parties
still-
have more of a relationship. These parties really didn't, and they seem at odds, and that's unfortunate.
You have your 2 minutes, Mr. Fisher. Let's see what Mr. Bachner wants.
Thank you very much.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Larry Bachner. I represent Christopher Graham. He is Anta's father. And, Your Honors, I think the Court hit the nail on the head. First of all, if I may just say, this is not the parents fighting. If I may be permitted some editorial comment, this is a case of selfishness. It is a case of one parent who is treating this child as a piece of chattel, which this
Which
Court...
one are you talking about?
The mother.
They seem to both have a little in this.
Well-
So let me ask you this, didn't the father
yes.
move? Isn't that
The
where we
father
started
moved,
this?
yes. The father, well, it didn't start
There's enough
anything.
to go around. Why don't we get to the issue of whether or not there's enough in the record?
Okay. Your Honor, the record is replete. Referee Negron, who presided over this for some 2 or 3 years, heard extensive testimony, rendered her opinion. The appellate division affirmed. Those facts are binding here unless they're not soundly supported in the record, and they are. If you read through Mr. Fisher's brief, Your Honors, you would think that Referee Negron didn't hear what she heard and the appellate division didn't read what it read. It's Mr. Fisher's interpretation of the facts are diametrically opposed to what is contained in the record. And if I may permit, Your Honor, there's a broader issue here, which I try to allude to in my brief, and that is the difference in the way these cases are interpreted when it's a custodial parent making an application versus a non-custodial parent. If one looks at Justice Roman's dissent in the Second Department, where she refers to uprooting the child from home, school, activities, and friends, as if the child is being
You're saying
dumped.
that's not relevant?
It is relevant. However, Your Honor, if one looks at another Second Department case from last year, 2014, where Justice Roman joined the majority, Doyle versus Debbie, where a child had been living with a father for 5 years, 5 years. The appellate division, the second, and the referee awarded, the judge, Judge Salonitra, awarded custody to the father, joined by the law guardian. Second Department reversed, said we don't care about those 5 years. Believe it or not, the 5 years did not count against the mother because she timely filed her petition. The Second Department's words sent the child to the mother to live in Georgia.
I'm not sure where you're going with this,
Pardon?
counsel. I'm
What-
really not sure where you're going with this.
What I'm saying is that, Your Honor, is that under the change in circumstances, Mr. Fisher is arguing essentially that the change in circumstances should be increased to something akin to extraordinary circumstances, or even the Suarez v. Williams, something less than extraordinary circumstances. He wants to tighten the standard.
Let me ask you this.
I want to loosen the standard.
Well, nobody argued the standard in the lower courts, so as far as I can tell, it's probably not preserved and probably not before us. But on this record that is clearly before us, as it's been said already, there were both the courts and the forensic examiner went to great lengths to point out the pros really and cons of both parents, and they really found, I don't know if you would say an equal balancing, but certainly some faults and some benefits on both sides of this, and did look to the, at least to some extent, to the wishes of the child.
Sure. I mean,
Correct?
I wouldn't even say it's an equal balancing. I would,
I didn't say it
Please,
was
I'm
equal.
sorry.
I
Okay.
said that
Yes.
there were, there was a balancing on both sides. It wasn't heavily weighted
No.
in favor of one or the other. So what do we know about the child's wishes?
well, to my knowledge, and Mr. Strauss can speak to that, because I haven't heard otherwise, to my knowledge, this child from age 7 through age 15 has wanted only one thing, that is to live with her father, to live with her stepmother, who she named in family court as the one person she'd like to be on a desert island with, if she could.
Yeah, that was kind of painful for the
Yes.
parents, I would think.
I'm sure it was, but it is most telling. And
Well, it just
that's,
seemed to be, in fairness, it seemed to me that the child was conflicted.
The child was
As any
conflicted.
child would be in this situation. You know, stepping aside from that a second, one of the issues that hasn't been discussed by council, and that it interested me, was whether or not a working mother is being penalized simply for being a working mother. I think you should address that.
That's what I wanted to touch about, Your Honor, because that has nothing to do with this case. A parent's work hours has always been a factor for the court to consider. Linda R., which Justice Roman cited, says that it should be done gender neutral. In Linda R., the mother's work hours allowed her greater availability for the child. That's the case Justice Roman cited. Nobody's saying being penalized for work hours, but if you are a parent who is an overachiever, highly successful, and you decide to take your work hours and you want to work another 20 hours a week to make an extra $20,000, and that affects your child to the point where the child is profoundly lonely, has no social activities, no friends, and is sitting home alone, there's a price to pay. If the mother's name was
Well,
named...
let's slow down.
Certainly.
Slow down a second. We're concerned with the larger issue than this case. In this case, I could see both sides. I could see another side that says a person works hard so they can afford to send your child to the best schools and to change the quality of your life. And that when you're the only parent doing that, that creates a greater burden on you if you don't have a spouse at home or a significant other person at home to take care of your kids. So that kind of fairness argument, that's what we can't do here. And that's what you're asking us to do. I don't think we can do that here. I think that's beyond our jurisdiction. The record doesn't support it.
but
The
Judge-
larger policy issue is whether or not somebody who's in that situation is being penalized simply for being a working mother.
No, nobody's penalizing her for being a working mother, Your Honor. The mother worked at I think it was a $90,000 a year job from 2004 to 2007, which allowed her great flexibility. There was no problem. Nobody came to court. Father never came to court. This started when the working parent decided to take, I suppose, a much higher...
I thought it started when the father moved.
Well, it started in 2007.
Well, did it start when the father moved?
Well, mother started it when father moved. Father started nothing.
Well, he moved and
He
made
moved.
the
He
trip
moved.
longer and made it
He
all
moved.
difficult that way.
He had a family. He bought himself a house in Babylon, Long
Right.
Island, not the ends of the earth.
Entitled to do.
Entitled to do,
Fair.
right? I mean, on relocation cases, people move to London, and the second department has affirmed it. It happens. People move. But nothing outrageous, so it increased the travel time for the child an hour. The child was traveling an hour to go to school from Queens in Manhattan in any event, even though I believe there was a UNIS school in Queens. Which, by the way, to address what Your Honor asked, that was a unilateral decision made by the mother.
Well,
mother
the fact of the matter, it seems to me, and I certainly understand both of you, you're arguing specific facts, and we just don't have the authority. And there's persuasive evidence on both sides. A couple
Do
of
these
judges
parents
said.
understand yet that no matter how this comes out, that for the sake of their child, they have to start working together?
Well, the father does. This is a child.
Well, I mean, I know in litigation,
but-
there's a lot of pointing
how-
fingers and name-calling and...
How does one work together if you have a child that says repeatedly, I want to live with my father, and the other parent for 8 years says, no, I will put every stumbling block in the way. I will file every motion. I will file every appeal
now-
that
yeah,
I
we're-
can to stop it.
Counsel, don't we have, or doesn't the court, and didn't the court take into account the age of the child when the child said that? I mean, if a child is 3 years old and says, I want to live with my father, I mean, you know, it's just, or I want to live with my mother, you're not going to put a lot of store in a
That's
3-year-old's wishes.
And
right?
that's why in 2004, mother was awarded custody, and father didn't fight it. He didn't appeal it. But time goes by. The child in 2007 and 2008
Right,
was
and-
4
and
years
so
older.
I'm most concerned about now. The
Now-
child want to hear from
I
what
would
the
have to
child wants
defer
to do
to-
now,
to
if
Mr.
she's changed
Strauss.
her mind or not.
To my knowledge, the child's opinion has only strengthened, not lessened.
Okay.
If there are no other questions, I'll conclude.
Thank you, Mr. Bachner. I think we have your argument.
Thank you kindly, Your Honors.
Thank you. Mr. Strauss? I don't think I have to say this, but I get nervous when, we have in-camera testimony that obviously isn't in the record and shouldn't be part of oral argument, but I assume you know that, so
No, I appreciate the
I
comment.
just feel better when I say it.
I appreciate the
Thank
comment. May it please the court, the court's already aware, I do represent Ante Kayla Cisse. She is soon to be 15 years old. She does wish to live with her father. I'm not divulging anything from the in-camera in that regard.
And she's told you this recently?
Yes, very recently. I've been in touch with her this week, and I know her for, I would just add very quickly, I represented her in the very first proceeding, which was alluded to by counsel for the mother, in 2003, when she was a little, essentially baby girl.
So you've watched
And
her
my first
grow.
experience, just very quickly, my first experience with her, which I recall, was going to see her, and she was eating from her, in her high chair, off of the tray, peas and carrots and chicken. I recalled it, I don't know why, but I do.
You could
And
almost
now-
take her as a tax deduction, you know?
We relate, what can I say? I mean, we can speak to one another, which is nice. So, and now she's in ninth grade, still at the Eunice School, given all of the court activity. She's not doing as well, I have to divulge to the court, I'm sure the court will have concerns about that. She's not doing as well in school currently as she might be. She is in the midst of this very protracted and very difficult process, and
Well,
she
let me
feels
ask you this. You're on the respondent side over here. You're obviously advocating in favor of affirming the appellate division.
that is true. I could
All
have
right.
easily sat
And
on the
if-
other
and if-
side, however.
And if it was the opposite, I'm suggesting, do you have the authority to bring an action in family court on behalf of the child? I don't think you do you?
No,
You're not a
to my
party.
knowledge,
You're
I've
not
never
a
seen that done.
Yeah, you're not a party. I guess you're a party, but not a party.
Right. I mean, that may be possible. I've never in my
Neither have
25
I.
years of
But I
experience-
guess what you could do is go to the parent whose support you're looking for if you want to make a change and ask them to do it. And then you'd still be done, you'd still have the same legal strictures of best interest, but also a substantial change in circumstance.
Yes. The way I view this case is that there were changes in circumstances which opened the door to an examination of best interest yet again. And of course, she was essentially a baby, or at best a toddler, the first time around. And then the second time around, which did commence a very long time ago, it is true, there was a mistrial. One of the judges did retire, a referee actually, which referred it to another referee in our courthouse, both of whom I have great respect for. I think that both of whom would have, the first one would have done an excellent examination into the circumstances, and I believe the second one did too.
I realize it's not common for JHOs to retire or referees to retire, but I'm just trying to think of my own experience, and it's limited. Things can get pretty lax in family court. I mean, they're very busy. They've got a lot on their calendars, and this one just seemed to get away.
This one seemed to unfortunately have a special set of circumstances that were not beneficial. I would have to say to nobody's fault. Now, I would just add very quickly, the court system that I'm involved with, the Queens Family Court, we now have a trial-ready part or trial-ready parts, which I
They
stated.
go straight, right? They just.
Yes, and that happens. I mean, I've seen it happen. It could be a neglect case, could be an order of protection case, could be a custody case. But that doesn't change the fact that sometimes some cases do, because we have attempts at settlement. I've alluded to, or I've stated, not even alluded to, I think I've been quite explicit in my papers, that throughout the course of time, these parents just are incapable, and it's sad, it really is, and Anta feels it. And that's part of the reason, I'm trying to capture key points as best I can, but the failure to obtain therapy for Anta throughout the proceedings, and as stated by the expert, Dr. Yohananoff, and I think it was very clear that this young girl, who now is an older but still young, could have greatly, and still can.
Is that what tipped the scales, do you think? The mother's resistance?
I really feel, and I have to tell you, I struggled over this situation quite a bit myself.
Because of her fear of the impact on the proceedings at the
Yes,
time.
the mother, in her own testimony, to the best of my recollection, I have reviewed it quite a bit, did state that she had a fear
Yes.
that if she had...
Be used against her.
Yes,
Yes.
yes. But she, in my thinking, the mother should have taken it to the next level, which is not so much, I don't care what happens to me in terms of how I'm viewed by the judges, but I have to do what's right, what's best
No,
for
I
my child.
understand, but
Yeah.
I'm saying, is that based on this record, considering that, I think Judge Stein has already mentioned that you've got record support on both sides in many ways. I do think it's at equal poise, but is this what tipped the scales?
I think it was part of what tipped the scales. Perhaps it was, if you could look at the scales, this was one of the larger pieces on the scale, but there was also, there was less in terms of what, in my estimation, what benefits a child. There was less on the mother's.
Is that because she's working all the time?
I struggle with that concept too.
Studying and doing everything else all the time?
I don't think it's just that. I think, yes, I think she did work hard, and she does continue to work hard, and I agree. I respect her for that personally, and I always tell Anta that I respect her mother for that, but she left out, in my estimation, as the attorney for Anta, she left out key pieces of the puzzle, not the pieces that perhaps we all might say are vital. Well, I think they are actually vital, because she really had no friendships and continues to have no friendships in her home area, which is Lefrak City, which is part of Queens. I know in today's
Are you
world...
saying that's what's happening now? Because I thought there was some change in that even. Now that she's 14, according to the, counsel for the mother.
I'm sorry, Your Honor. Her life has changed quite a bit. She is older. She's involved in two key things. She's involved after school. When she's at mom, she goes to swimming on Mondays and Wednesdays. She's involved in the play Rent. She likes drama quite a bit. And she's involved with that Tuesdays and Thursdays when she's over at her dad's.
Is that in connection with the school? I'm curious about whether she would stay at the United Nations school or whether she would go to some other school.
She wishes, and I want to make this clear too, she wishes to experience the type of life that she experiences at her dad's home.
Meaning going to public school in that area?
Right, and not just that.
There's a difference in parenting choices that are both equally viable, or is there something really distressful about the parenting
No.
choice of the mother?
I would be,
Because I know the expert, at some point, argues this, those are parenting choices and they're fair choices.
and that's part of the struggle that I've always had with this, is because no one can point to either parent and definitively say deficient or problem parent. They're both very, very good, separately. Together, bad.
If you're at that equipoise, then how do you make the choice?
Well, now I have an older client.
No.
Oh, I'm sorry.
At the time.
I
At the time
Large-
that the courts made that choice. If you're truly at equipoise, how do you make the choice?
think the choice is based on the ability of the one parent to more get a sense of who the child is and what the child really needs. It is, I'm not going to say it's not a fine line, it is. But in conjunction with my young client and listening to her over the course of time, this is her wish. She wishes to experience this. She has siblings there. I know the court is aware of that. This is the way life plays out also. The father got married and had other children and moved to Long Island. And but it all comes back to that, in fact, this is what Anta wishes. And I think Anta's wishes are based on criteria and analysis that we can all appreciate. I don't think it's just a
As
young girl.
opposed to the whims of a child.
Yeah, exactly.
Okay, I think we have your argument, Mr. Strauss. Thank you.
Thank you.
Mr. Fisher?
I'd like to remind the court that in his summation, Mr. Strauss said custody of Anta would be well served in either household. So when you talk about this very fine line, my client, as
Still back to, I get that, but, you got demeanor evidence, you've got, so much that goes on in a courtroom, and we've got now a family court that makes a ruling, and we've got an appellate court that sustains it, and we can say, well, it was close and whatever, but we don't have any fact-finding ability, right? I mean,
again, unless you find that the facts as found by the appellate division are not so amply supported by the record. And I think,
well, no, their job is to see if the family court was right, and if they were opposite. In other words, suppose the family court said mom, and the appellate court said dad. I think then we would, we'd take a look at the evidence and see which one more comports with the court. But I think if they all agree, I don't think we can then say, well, we think they're all wrong.
well,
Unless there's a legal-
Justice Roman didn't agree, and that's
Right.
why she gave her dissent, and I respectfully agree with Justice Roman's dissent, and her finding that the father did not make a case so as to warrant a change of custody, that he didn't meet the heavy burden imposed upon him. The bench this afternoon is saying we're walking a very fine line. Both parents were found to be fit. She has thrived with the mother with whom she's been for 15
Are you missing my
years.
point? No, and I agree. I see what you're saying. All right, you're saying there's a judge that agrees with me. Unfortunately, there's 3 over here, and there's 1 down there that agree on the other side, and you're saying ignore them. They're wrong. They're flat out wrong, and they're wrong as a matter of law. And the reason they're wrong as a matter of law is that he didn't sustain his burden, right?
He didn't sustain his burden,
But the
and many
family
of the
court thought
facts
he
that they
did,
found
and the
were not
appellate court thought he
accurate.
did.
If I may, I know I have limited time, I'd just like to Judge Fahey's comment about working mother, because I think that was second to the priority, second to the child's preference. I think that was a very important consideration. And when you talk about facts that have changed, significant facts have changed. When this hearing was pending, the mother was studying for her Chartered Financial Analyst test, a series of 3 tests, and she has since passed that. A lot of the work that she was doing at home related to studying for that test. She passed that test in June 2014.
I don't mean to interrupt you, but are you saying that we should now make that finding of fact that you're arguing and reverse the courts because we've made a separate finding of fact that now that she's succeeded in that we now have jurisdiction to do that?
Well, it would be wrong, I believe, for this court to simply affirm the appellate division when so many facts have changed.
Well, don't you have to go back then to the family court and say you made a decision based on something else, the facts have changed, and we want a rehearing? I don't know how we can do it, is my point.
This,
The best that you could hope for, I would think, here would be a de novo hearing. That's why I asked you about it before.
well, again, my hope would be for closure and to bring a conclusion
Understandably, but I'm
to these
telling you,
proceedings.
Legally, I'm not talking about.
Right.
What's best is not to be here, right?
But-
It's the best
but
for
the-
everybody, but you are, and so the most that we could do would be to consider a de novo hearing. And I'm trying to struggle to see how you meet the requirements for that.
Well, again, many of the facts have changed. Many of the facts that the family court based its decision on are outdated, such as this, where the mother is no longer studying for this exam, no longer putting in the hours. I mean,
Wouldn't that be the case, counsel, with every case, with every family court custody battle or change of circumstances, visitation, modification of visitation battle that ultimately made its way up here, even if it were timely? Wouldn't there be changes over a period of time? And
there are always changes in a child's life.
Exactly.
But we have to look and see how significant they are and whether we're basing a decision totally on facts that are outdated. And are we looking at 2 different children?
What's the rule that you would want us to come up with? What is the rule for not just this case, but other cases?
The rule is that custody cases need to be heard on a timely basis. And when you have a case like this where there were 14 trial days over 18 months, and then you had the in-camera and the summation, and the judge rendered a decision, when the case is 2 years from start to finish, 2 years in a child's life is rather significant. And when you add probably another year and a half for an appellate ruling, you're talking about a 3.5-year process, which in the life of a child is very long. You know, a fifth grader is not a seventh grader. A seventh grader is not a 10th grader. That's just the facts. I do believe that the mother was prejudiced in this case for being a working mother, and I think there should not be any negative implications.
Did you make that argument in front of family court?
I did not try the case.
Did Ms. Cisse make that?
Well, the mother's work was scrutinized extensively. The father's statement that he also works from home was virtually ignored by the court, and it's not even in the court's decision or the findings. The father's a teacher, but
in his benefit, I would think that it shouldn't make any difference to you.
Excuse me?
If he's working from home, he can supervise the child. I wouldn't think that necessarily would inure to your benefit.
But the mother's work from home was criticized by the court. The father's work from home was ignored.
Well, I think the point you were trying to make was that his statement was not scrutinized with respect to what that meant, that I'm working from home. Does that mean he's got time for his daughter or not?
Well, I assume working from
As
home
I
means...
understood your point was, but the mother's time working was scrutinized.
Correct.
To determine whether or not the work impacted her ability to engage with her daughter and have time with her daughter and respond to her daughter, whereas the father's work was not. I thought that was the argument.
Correct, as well as the fact that the father has 3 other children for which he has obligations for.
Was that raised in front of the appellate division?
Yes.
Okay. And they came out with a decision they did?
Yes, they did, Your Honor.
All right. I think we have your argument, Mr. Fisher.
Thank you very much. Have a good day.
Thank you for your time. People